Ready, start. However, the Sessions Court, having primarily proceeded on the premise of there being no objection from the side of the prosecution for grant of bail, it would have been just and proper for the High Court to direct the Sessions Court to consider all the relevant factors and decide afresh the application of the appellants for bail. Evidently, in the absence of the Sessions Court looking into all relevant factors for grant of bail, the High Court took upon itself such a responsibility, looking at the gravity of the alleged crime and the apprehension of evidence being tampered and witnesses being susceptible to influence and intimidation. The High Court proceeded to revoke the bail. What weighs with us now in the facts and circumstances of the present case is whether the High Court ought to have revoked the bail for the reasons that it assigned, or should the High Court have directed the Sessions Court to decide the application for bail afresh. Directing the Sessions Court to decide the application for grant of bail is an available option to us given the circumstances noted above, but having regard to the lapse of time and the submissions advanced, we propose to decide the appeals on merits. Apart from the aforesaid fact that it has not been shown to our satisfaction that the appellants violated any of the conditions of bail except in one case, which we propose to consider a little later, we are of the considered opinion that, notwithstanding the gravity of the offences alleged against the appellants, the conflicting interests of individual liberty on the one hand and the victim's rights as well as concerns for community safety on the other could have been better balanced, bearing in mind that the appellants had suffered incarceration for nearly a year and thereafter had been on bail for almost 2 years before the orders granting bail were revoked while the impugned order. The likelihood of the accused influencing the witnesses or tampering with the evidence and ensuring smooth progress of the trial could have been taken care of by imposing stringent conditions over and above those which were imposed while granting bail. The presence of the antecedents of the accused is only one of the several considerations for deciding the prayer for bail made by him. In a given case, if the accused makes out a strong prima facie case depending upon the fact, situation, and period of incarceration, the presence of antecedents may not be a ground to deny bail. There may be a case where a court can grant bail only on the grounds of long incarceration. The presence of antecedents may not be relevant in such a case. In a given case, the court may grant default bail. Again, the antecedents of the accused are irrelevant in such a case. Thus, depending upon the peculiar facts, the court can grant bail notwithstanding the existence of the antecedents. The cancellation slash revocation of bail no doubt seeks to uphold trial integrity.